Good evening and welcome to the Kent County Board of Adjustment meeting for November 17th, 2022. Calling this meeting to order. When you're ready, will you call the roll?
Thank you. Ms. Hudson.
Here.
Mr. Jenkins.
Here.
Mr. Cusick.
Here.
Mr. Nichols.
Here.
Ms. Coleman. And Mrs. Denny.
Here.
Vote shows 5 present, 1 absent. We do have a quorum.
Thank you. Will you introduce the staff?
Thank you. Good evening, everyone. My name is Scott Blair. I'm one of the planners here with Kent County Planning Services. Also with me to my left is fellow planner Jamie Fensky, and to her left we have Mr. Mark Kennedy handling IT for this evening. And at the other side of the dais we have Mr. Fred Townsend. He will act as the board's legal counsel for the evening.
Thank you. At this time, I'm going to ask everyone to rise and pledge allegiance to our flag. So, any additions or deletions?
There are none.
Thank you. So when you're ready, introduce the public hearing.
Thank you. Good evening again, ladies and gentlemen. My name is Scott Blair, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony in these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. We do ask that everyone limit their testimony to 5 minutes and stay focused on the variance request. However, the chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make a statement when your application is called, please use the podium at the front of the room. If you are participating online and wish to give testimony, we will unmute your line so that you may speak. For the record, please give your name, address, and allow our attorney to swear you in prior to providing any testimony. Copies of any written statements or exhibits used during the hearing should also be presented to staff for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by staff. The board will then receive testimony from all those in favor of the application, followed by testimony for those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471 or check the Kent County Planning Department website to learn of the board's ruling. All applicants will receive written notification of the board's decision. However, this notice may not be mailed until after the next scheduled meeting. But if approved, you are welcome to apply for any necessary permits before receiving it in the mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on October 30th in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the application. Thank you.
Thank you. This time we're going to have a statement from council, the purpose of which is to help those who are going to give testimony before the board tonight an opportunity to understand what is appropriate testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denny. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The legal standard for area variances considers whether a literal interpretation of zoning regulations result in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors: the nature of the zone where the property lies, the character and uses of the immediate vicinity, whether removal of the restriction on the applicant's property would seriously affect neighboring properties, and lastly, whether failure to remove the restrictions would create an unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met when the difficulties alleged are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty, for example. And it is also at this consideration where the board considers whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board is not permitted to consider factors other than the 4 listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the nature of the zoning district, the characteristics of the area, thirdly, whether the requested variances would seriously affect neighboring properties, and lastly, whether applicants are confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners. Ms. Denny, that's my remark.
Thank you. So when you're ready, let's start the public hearing.
First, we have application A-22-33 for Lafferty. Is there someone present for this application? Thank you. So we have applicant owner is Kevin and April Lafferty. Present zoning district is AC, Agriculture Conservation. Proposed variance is a variance from the requirement that a fence may not exceed 4 feet in height in the front setback to install a fence. Present use is residential. Proposed the same with a fence. It's in the Levy Court District 1 for Miss Maston. It's located on the northeast corner of the intersection of Willowwood Drive and Magnolia Avenue, being lot 252 in the Willowwood subdivision, south of Smyrna. Here you will see the variance from the requirement that a fence may not exceed 4 feet in height in the front setback to install a 6-foot fence. They are proposing a fence to be installed approximately 13 feet away from the front property line on Willowwood Avenue. You will see in green the proposed fence placement, and the blue line there is the 25-foot front setback on both Willowwood Avenue and Magnolia Avenue. Here is looking down the road, the corner of Magnolia and Willowwood. Looking down Willowwood, back at the beginning of the front of the subdivision, the side of the fence. This is looking from Willowwood at the fence. It's currently there. And at the fence. The entrance to the Willowwood subdivision. Front of the dwelling. The other side. And aerial. Sir, if you would like to come forward, state your name and address, and allow our attorney to swear you in, please.
Kevin Lafferty, 19 Magnolia Ave, Smyrna, Delaware.
Mr. Lafferty, I'm going to ask you to pull that microphone a little closer to your face. Thank you. Sir, Mr. Lafferty, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
We are requesting this variance because my son is disabled. He's autistic with elopement tendencies. When we first moved into the development, we did secure permission to put up the 4-foot fence that you saw. He can easily climb over that, and the corner of Brentford and Willowwood is a busy corner. We feel that requesting the 6-foot fence would help secure our son in the backyard, make sure that he can't get out and get hurt. He's also nonverbal, so when he does elope, he has no way to find, his way back home. We have had, actually our first night in the house, we have had him run out of the house, and he was returned to us about an hour later by the state police. So we feel that while it is not in the HOA or the zoning variance, the zoning rules for a 6-foot fence, we feel it's not an undue burden to have our property have a 6-foot fence for the security and safety of our child.
Okay. Does anybody have any questions of
Yes, I do.
Lafferty?
How much of this existing fence would be removed to include the 6-foot new fence?
It would actually be right along the same lines.
All the way around, all that perimeter would be 6 foot?
Yes.
Anybody else? So I have a couple things. First of all, just as a matter of housekeeping, for the record, I want and you probably are aware, but I just want for the record to show that we have received 30 pieces of correspondence from residents in the community asking us to not approve this because of the nature of continuity in the community and the homeowners' rules, and of course, people feel that when if they buy into a neighborhood and they've examined all these regulations, that is how things are going to be. The second thing I'm going to say is, while we do take into consideration the correspondence, issues with a homeowners association are not settled before this body. They are civil matters that would, if someone desired, they would be heard before the justice of the peace. It would not be heard by this body. So I just want that. That's housekeeping. So what would it be? I don't even know how to phrase this question. So what difference would it make to you if this did not surround the entire house, but only the backyard, and you were able to secure appropriately for the nature of your son's anomaly, the front, so that this wouldn't be the entire property, but just what we would consider the backyard, which would begin, of course, with the back of the house?
We're not seeking to do the entire property. We're seeking to replace the existing fence with a 6-foot fence. So it would be the back of the property.
So it would be exactly what that white fence that is there.
Yes.
And you would make it a solid fence.
Mm-hmm.
Okay, and then, of course, the second issue, I think, is that, I have to look at this again, but you were also talking about the possibility of making the side, one of the sides, 13 feet from the property line, which a lot of the neighbors feel would encroach on vision and, the sidewalks and a lot of other things that we read in our letters. So I just want to bring that into play as well. And at this point, I'm going to see if anybody else has any questions. Mr. Townsend, please.
Thank you. Could we see the Exhibit B? Okay, so just to be clear, Mr. Lafferty, is it your desire to have a 6-foot fence that is running along the green line?
Yes.
Okay. So it's not around the entire perimeter, and it's not entirely within, or not entirely along the existing fence. In other words, the area there on the left is set in from where the existing fence is now, is it not?
It appears that, oh, I think that's a staff. I mean, is that probably right away there? And then the property line? I mean, the existing fence on the property line now?
Actually, I believe you have two different pictures, or taken two different times. We initially got a 4-foot fence that was almost right up on the curb. We were then informed that we were encroaching. We didn't have the easement back from, so we moved the fence back, and that's currently where it's at now. So the 6-foot fence would run along that line and not right up on the curb.
So do we have a approximate distance between the boundary line along Willowwood and the proposed location of the green fence?
I believe it's 13 feet.
Is it 13 feet in from the property line? Does that seem right?
Yes. And to answer Mr. Cusick, normally properties do sit off the roadway more than this one. This one is much closer to the right-of-way than, or the roadway than typical properties.
And that was appropriate for the permit at the time for the county, like for that house to sit in that position? That.
Yeah, and what I believe there is, I believe this is a 70-foot right-of-way, but this entrance is extra large and then it thins out a little. So this property actually does go way closer to the road than the typical property would.
Okay, and that all happened, I guess, when that was platted, back in the original, when the development was, okay, all right,
At that picture, so
that's better.
that's right
yeah.
on the road
Right
there,
on,
it looks
practically
like,
on the
versus
road,
the picture
exactly,
that you took.
yeah.
And
So
this
this area-
is what Mr. Lafferty was explaining.
Yeah.
They originally had a fence that went closer to the road, and they have since moved that in. If you notice this tree that's here, that's that tree there. So they have moved it in.
So as it exists, it meets code. It's the right height and the right distance from the road.
Yes.
And of course, this is a double-sided lot because of the corner, but it backs up to open space. So a huge portion of this being the back fence, the back of the property line, is all an open space.
Yes, ma'am.
And so I'm asking, but, so the area up to the, that backs up to the open space, if that were higher, it's not going to impact views or any of those things. We're really more concerned about the sides and the front.
Inside of that blue line, they would be permitted to have a 7-foot fence all the way to the property lines by code.
By code.
So the variance is only required for the rectangular area that is running left of the blue line towards Willowwood. So I would ask Mr. Lafferty to explain the need for that area there. In other words, if the green line ran along the blue line as it runs parallel to Willowwood, you wouldn't need any accommodation or variance. So could you explain the need for that additional area?
We were just requesting to replace the existing fence that we have. That's the only reason why we went in that green line. There is actually no real need to go past the blue line, other than to give us a little bit bigger backyard that was enclosed.
Okay, so, and without that area, then we wouldn't be here. Because as you can see, within that blue line, you are permitted to have 7 feet. A 7-foot fence. So it's that small area that stands out that brings you here this evening. Am I right? I'm just looking at my planners and saying, is that so?
Yeah, that's right.
Okay. Okay, so, all right. That being said, anybody else?
I have a question. If this were granted, would there be anything in the backyard that would be contributory to your son escaping this 6-foot fence?
Currently, no.
What is the age and the height of your son?
He is 8, and I would say he's about 4'9", 4'8".
So you're saying there's nothing now, but that doesn't mean in the future there couldn't be.
Maybe I'm misunderstanding your question.
I'm asking this because if it was granted and he was clever enough to put the right object in the right location, he could still escape.
Correct. But currently we don't allow him to go into the backyard because my wife is also disabled and she can't chase after him. So the idea would be that he could go into the backyard, but there would not be ladders, slides, stuff like that he could then make into something to climb over the fence. It would purely be to have him be able to go out in the backyard and enjoy being outside rather than being in the house 24 hours a day, minus the time he's in school.
Just one additional follow-up. So when you testified earlier, you reported that he escaped. Was he in the house and he got out the front door, or did he escape
Yes.
over the existing fence?
He went out the front door, 5 o'clock in the morning.
Thank you.
Anybody else?
Mr. Lafferty, is it your impression that you save money if you use the current location of the fence to install a new fence? Or no, right? I wouldn't think so, but I'm just asking. So you've got some room on the opposite side, on the right-hand side of that lot, to move the fence closer to the property line, right? Which would give you a little more area. Doesn't require a variance because you can have a 6-foot fence or even a 7-foot fence. You're asking for a 6-foot fence, but you could have even a 7-foot fence that follows the contours of that green line on the right-hand side and along the back where it says open space. And it could jog up on the Willowwood side as it does. So you're tracing, Jamie, the blue line. That's the setback area. They're not proposing to have a fence in the front, though.
Correct. So, but where those 2 blue lines are, the line that goes up against the open space and that property line to the right, he could have a 7-foot fence. He would be permitted to have a 7-foot fence.
Okay, I was just confused by the cursor because he just wants a fence in the location of the green line right now, but he wants a taller fence along Willowwood where it's prohibited beyond the blue line. That's all we're talking about. So you wouldn't need a variance at all from us or any relief from the county code if you just didn't include that area right there within the fence. If you didn't fence that area in, if you just ran the fence along the blue line 25 feet back, and you could even run it all the way over to your opposite boundary line, and you could enclose almost as much area as you're proposing to enclose. Is that a concern? You're trying to get as much area behind the fence as possible? Do you think does your son need a lot of area and he's doesn't have enough within the blue setback? Is that the concern?
To be honest, I would have to see physically what the blue line, looking at what the backyard would be with that. I'm just going by what we have right now already fenced in.
So what do we think the distance is between,
Could you go back to the aerial? So right where it jogs back there, in the back property line, where it jogs down, I would say probably to move. Can you move the cursor like that little section of? No, that where it jogs back. Yeah, that one. So if you move that where that fence is to the left, probably 10 feet maybe, and then bring it straight. That will be where the new fence line will be.
that gate is on the front, maybe running straight back from the gate somewhere? If that's a gate where the cursor is right now? The unfortunate thing for Mr. Lafferty is that you've got to incur the cost of installing an entirely new fence, and you're not getting any advantage from having installed the old fence when it comes time to installing the new fence. So you're not bound to stay in the current fence line. You don't have a financial incentive to relocate the fence exactly as it currently appears.
So essentially, where that blue line is, all of that could be 7 feet tall.
Not this blue line.
But in front of the house, it stops it. No.
The
Okay,
blue
I'm
line
missing.
is the lot line, right?
Yeah, and this was the property
This
line.
blue line is the property line, approximately.
But you can have where that fence is 7 feet high without even being here.
No.
Can we draw it? So
Yeah, the code would allow a 4-foot fence to all property lines, front, back, and rear. So perceivably, a 4-foot fence could enclose that entire blue area. It's when it goes above 4 feet, it cannot be in the front setback, of which there are 2 in this case because it's a corner lot, and that's why it has to step back.
I just want to make sure I'm clear. So, Jamie, if he ran the line on the western end of the property, he could bring that in to the corner of the house, or as Mr. Townsend said, somewhere around that gate, and run it all the way back, and then go 7 feet all the way around, following the current footprint of the fence that's already there, correct?
He would,
Would you trace it, what he could do, and have 7 foot all the way around?
so again, here, if you follow this blue line, and then all of this back here, all of this rear property line, and all of this side property line to this 25-foot front setback, he would be permitted to have a 7-foot fence. They are asking for a 6-foot fence to be 13 feet from the front property line of Willowwood. So they would have to move that fence back 12 more feet from Willowwood to be permitted without a variance to have a 7-foot fence. They are asking for this area to be within the front setback, 13 feet from the front property line.
Again, run that cursor about what, around the perimeter of what would be permitted.
That's not right. You can't, can they have a 7-foot fence in front of the house? Okay. All right, but that is that's not what they're requesting anyway. Right? They're requesting to run from that one corner on the right side of the house where there's a green line to, they could go further towards the sideline and go around to the other corner of the house, as long as it stays within the blue line.
Correct.
Mr. Lafferty, does that accommodate you and your son if you were to change that green line on the western side of your property?
It may. Like I said, I would actually need to see what it looks like without.
Do you want some more time to do that?
We could table this to another meeting.
But I'd like to request a variance, and then if it's denied or approved, I mean, I have a plan B at that point.
Okay, and understandably, however, if you come back for another meeting, like if you decide that doesn't work and you come back, you still have the filing fees. I'm just pointing that out. Okay, so once again, just so you understand, you could put 7 feet up all the way around where this particular blue line is. Okay, the other one, I was saying inside the other one, I was looking at we were on a different picture. So you can, without need to come here, have 7 feet all the way around. We certainly can continue with this evening, happy to do that. But also, when all this meeting is done, whatever way it goes, if you want to look at that and make a decision before you build your fence, you'll know that is all of that can be 7 feet. Okay. Is everybody good with that, or we have more comments? Or go right ahead.
I think we have some more questions.
I just wanted to make clear again what staff has indicated in council. Kent County Board of Adjustment does not have the ability to enforce deed restrictions, but you're aware that 30 parties in your community are opposed to your request. So even if this board were to agree to grant you your variance, that doesn't mean that other members of the community wouldn't have another opportunity to say that your variance is in conflict with the deed restrictions on your property. The other thing, I just want to ask this question. One of the respondents indicated that, I don't know how they knew this, that's why I'm going to ask you, that you were aware that you wouldn't be able to erect the type of fence that you're proposing to put on the property beforehand, before you acquired the property. I don't know how they knew that information. I'm not saying it's true or false. I'm simply asking you, were you aware that the fence that you're asking for, the variance that you're asking for this evening, was not permitted under the HOA?
So I won't.
Excuse me.
Yeah, I won't forbid Mr. Lafferty from answering that question if he wants to, but I will tell the board members that whether you're aware of a obstacle to your plans to develop a property does not prohibit you from requesting a variance. If you meet the standards for the variance, you meet them regardless of whether you knew that you needed a variance in order to execute your plans. So if you wish to answer that question, you may.
There's no need. You can do with that as you choose.
We don't, as has been said on a couple of occasions, we don't enforce restrictions that are imposed by the community. And the community restrictions may be consistent with ours. They may be even more restrictive than ours. I mean, we've indicated that as far as county code's concerned, you could have a 7-foot fence. Do you have an understanding of what the tallest fence is that you could have under your HOA provisions?
It's 4 foot.
All the way around 4 feet?
I am not sure if it can surround the entire property.
So like the rear of your property, you think you may only be allowed to have a 4-foot fence under your restrictions?
Yes.
Okay. So again, we're only here to consider the applicability of the zoning code to your circumstances. At some point, I guess we need to talk a little bit about the fact that you're seeking a reasonable accommodation due to the condition from which your son suffers, which casts a different light on this, and all the members have read the report. The report indicates that your position is that without the reasonable accommodation, your son cannot enjoy an equal opportunity to live in this community. Is that your position?
Yes.
So your position is with respect to that area that we identified as being the only area that requires a variance, which is the area between the blue line on the left and the green line towards Willowwood. That's the area that you contend your son needs in order to enjoy an equal opportunity to live in the community.
Correct.
But when I asked you about the need for that area, you said you didn't have a strong opinion as to whether that area was necessary.
It's only because I don't know how big the backyard would actually be and how usable it would be if we went along that blue line. I can only visualize what we currently have.
And is it the second or last standard, or is it the third standard that relates to, I guess that's a legal conclusion that the board can come to, but you've indicated that with respect to whether this variance would alter the plan for development in a fundamental way, you're saying it does not. Correct? You've made a submission indicating that it does not. Have I missed a standard? Are those the two standards that were to apply?
There's three, and it's number 3 that I think that it is a concern.
So I don't know what I have done. I don't.
Yeah, obviously, it's on page 2.
Oh, okay. It is on page 1, yep. It must be reasonable. So your position is, well, what is your position as to whether this accommodation you're seeking is reasonable?
I don't think it would affect anybody else unduly.
Okay. You may or may not be aware that zoning ordinances generally are going to restrict the height of fences that appear in the front yard because it can affect line of sight for traffic. Can you tell us why you don't think there are any safety concerns that are raised by your desire to have a 6-foot privacy fence? Is it 6 feet or 13 feet into the setback? What's the distance again?
They're asking to be 13 feet from the front property line. So
From
they
a
would-
25, or from the property line? Okay. From a 25-foot setback.
From the property line, they're asking to install a 6-foot fence, 13 feet from the front property line. So they would be in that 25-foot setback, 12 feet.
12 feet. So it's your position that the height of that fence is not going to create a safety concern for traffic or for pedestrians walking in that area? I guess there aren't many, is that right? Would that be your testimony?
As far as pedestrians, no, there aren't many, and that is a main entrance to the development. But if you can go to the side view of the fence, the trees on the left-hand side prevent seeing, as you're coming up Willowwood, which is the street in front, when you're coming up toward Brentford, the trees prevent sight onto Brentford, and there's also a monument wall that prevents view. So I do not feel that the fence being there would prohibit anything more than is already prohibited with the current plants and monument wall.
Anybody else? So just kind of as a recap, when we show you we see what you are requesting, and when we show you with where the blue line exists there, except for that little part that juts kind of juts out there on the left, yep, exactly, thank you, Jamie, then you wouldn't even have to be here. It's just that one area that really is causing this to occur, and I just want to be sure you understand. And at that point, I'm just going to ask, I'll give you an opportunity to make comment.
I
Okay,
understand that.
but, and at that point, is there anybody else who has something they want to say or ask? Go ahead.
I just want to make a statement. With regard to the yes, a question. Sorry. With regard to the criteria that we have to use for making a determination, it says it must be necessary using a but-for test to show that but for the accommodation, its inability to address the person's disability, the person will not be able to enjoy an equal opportunity to live in this community. If again, we were to change the proposed fence to be in conformity with county code, then the applicant would be able to enjoy the property the same as any other individual. Is that
a question for the applicant?
yes.
Tried to answer that question.
Yeah, I'm asking it again. Again, we have to satisfy all three of these criteria in order to be able to offer you the variance you seek. But the second one is the one I'm having a little trouble with. If the fence were moved, your son would be able to enjoy all but that small section, and I say that's small relative to the area involved of the property. And again, council has indicated you wouldn't even need to be here. But if you don't accept that, then you're asking the board to say, well, then, except for that, your son can't have full enjoyment of the property. I'm not sure you've made your case there, because you could get everything you want without having to even appear before this board. So would you want to reconsider appearing before the board and simply changing the position of the fence and then take your chances with the HOA?
I guess I could do that.
And I also just have a question, because it's of you, because it seems as though you're very hesitant here. And is there some type, it sounds like you don't have any type of equipment in the yard that your son could use to, gain height to access the ability to climb over the fence. Is there something that he does for exercise or something that requires that extra amount of area? It doesn't seem, of course, on a piece of paper, it looks very small, but it seems, I have 40 years in medicine, and many of it orthopedic, and when in primary care. And when I look at this, I think while I understand what you want, and of course this is his space, but I also am just questioning how necessary it is to add that little, and maybe there's something in your exercise routine or his routine that this is necessary, and this is your opportunity to express that to us, if that's so.
I was just trying to get as much space as possible in the backyard because my son enjoys running around. And to kind of wall it off, if you're talking 12 by, let's say, 20 foot long, that's 240 square feet that he would be eliminated from running around. That's the only reason why I was seeking the variance, to go along the existing fence line that we have and maintain all of the backyard for his use that we currently have. We just can't have him in the backyard because he can jump a 4-foot fence real easy.
Okay, thank you for explaining that. Anybody else? Oh, go ahead.
Yes, I just have one comment. if you look at that green area, I don't claim to be the world's greatest mathematician, but area footage, and you look at this section, that rectangular area that we're asking you about, would you agree that that zone is 5% of the total area in that backyard that you would lose?
I would say it's less than 5%. Or, I'm sorry, more than 5%.
I'll give that to you.
Anybody else?
One quick
Go ahead.
thought. I mean, it might be a cost savings to be able to reuse the existing posts that are already augured down. Just a thought.
Well, that's why I asked.
Yeah. I think it's also I think it's the applicant's, it's our right to vote on this application and not really push him away now. I mean, if this board denies it, then it's up to him to go to Plan B, which he could easily just move it back to that blue line. But I think it's the applicant's right for this board to.
It's his right.
Yeah,
It's his right
for
to be
him
heard. So I agree wholeheartedly. Anybody else? Okay, so at this point, we vote later. So at this point, thank you very much. Unless you have something else something to say in closing, but,
No, thank you for your time.
okay, thank you.
Is there anyone else that would like to speak in favor of this application? Please state your name and address and allow our attorney to swear you in.
If there's anyone joining us online that would like to speak in favor of this application, please press star 3 if you're joining us by phone, or use your hand icon at the bottom of your screen. See no hands raised online.
Again, last call for anyone that would like to speak in favor of this application. Is there anyone that would like to speak in opposition of this application?
Similarly, if you're online and you'd like to speak in opposition of this application, please raise your hand or use star 3 on your mobile device. No hands raised online.
Thank you. Seeing no one, the public hearing for application A-22-33 is now closed.
Okay, the next application for tonight is A22-36.
Sorry, application A-22-36 for Williams. This is, the applicant owner is Daniel Williams. Present zoning district is AR. They are seeking a variance from the 10-foot side setback requirement to place a manufactured home with an attached garage. Present use is residential. Proposed is the same with a manufactured home with an attached garage. It's in Levy Court District 6 for Mr. Howe. Located on the north side of Thicket Road, 0.23 miles east of Morgan's Choice Road, west of Camden. You will see here that they are seeking a proposed 14 by 70 mobile home with a 22 by 22 attached garage to be 5 feet from the side property line. This is looking at the property from the road, down the road, and in the other direction. Again, this is looking at the approximate location of the home, and you can see there where the septic currently is. That is a new septic on the property. A little bit closer. This would be the rear of the property, and there you'll see that ditch there that requires a 25-foot buffer from the ditch. An aerial. And a farther up. So gentlemen, if one of you would like to come forward, state your name and address, and allow our attorney to swear you in.
Name and address for the record, sir.
Dan Williams, and the address is 227 Thicket Road.
You said Williams?
Williams.
Mr. Williams, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. I'd like to see if my contractor, Kevin Hanna, could come up and help me answer any
And
questions.
how we do this is you tell us what you want, and then we'll ask for anybody else in favor, and he'll be able to interject or tell us anything you missed.
Sure.
Okay. So go ahead when
Oh,
you're
I'm
ready.
sorry, I'm sorry.
That's okay.
So I purchased the lot with, there was already a mobile home in place. We tore down the mobile home, and we're interested in putting the same size mobile home there, 14 by 70. So we just wanted to attach, we're just, if you see where the grass is cut there, we were just going to be 5 feet away from the actual property line, as opposed to 10 feet. So we just wanted to encroach, I think, 5 feet from the property line.
Does anybody have questions of Mr. Williams?
So the existing mobile home is going in the exact same location, which was
Yes, pretty close.
Size-wise, it's close to the same size, and it's going to be as close to the same spot as
Correct.
you believe the other one was.
Correct.
Okay. Anybody else?
Is there anything that we can look at
yeah.
To
I don't even know
see-
what I'm looking at here.
to see
this
the
picture.
where the encroachment would occur?
So the blue would be the mobile home, and then the red would be the little garage.
Mr. Williams, could you raise that microphone a little
I'm
bit?
sorry. The blue would be the mobile home, and then the red would be the little garage.
At this time, there isn't a garage there, or there was a garage there?
There was not.
So
It was just a mobile home.
it's just the addition of the garage that,
Correct,
okay.
correct.
But Mr. Williams, if I may, there's nothing on the site right now except for the septic, right? There's no
Correct.
home, there's no garage,
Correct.
just the septic.
Correct.
So what would be, the red box is the garage?
Correct.
Yes.
Would there be anything on the other side of that garage?
If you'll see here, there's this circle. That's the approximate location of the existing septic that's there.
So nothing to the right of
No.
that garage area?
Just grass.
Thank you.
Oh, and just for the record, you can't get any closer to the septic.
Correct.
I think that dimension
Denrick-wise. Yeah, okay.
That dimension says 10 feet, I believe. That's where it's at now.
Yes, that does say 10 feet there.
Anybody else?
Could you just, is there like an aerial just to see what's surrounding? Yeah, there you go. Thank you. That's like a private drive lane between the two properties?
Yeah, that's the neighbor's driveway.
Okay.
And that is how you ingress, egress to your property as well with that driveway?
No, it'll be the,
Mr. Williams, you can point right on that screen.
sorry.
If you touch it,
Oh.
a pointer will come up.
the other driveway will be right there. That's
Okay.
my driveway. That's my driveway.
Okay. All right. Anybody else?
So that lane that is to the right of where your garage is going to be, it just goes back to another property, another
Correct.
house? Thank you.
That the garage could be placed elsewhere on the property without requesting a variance. I'm asking a question. Could the garage be placed elsewhere on the property without requesting a
No,
variance?
sir, because we're surrounded kind of by a tax ditch. That was pretty much the only place that, behind the property, back here, is a tax ditch. So I have to be so many feet away from the tax ditch.
Anything else? Well, at this point, I think no one seems to have any more questions of you, and if you do want someone else to come up after you sit, they're welcome to come up.
I think
Okay, thank you.
Name and address, please.
Name is Kevin Hanna, 4417 Barrett's Chapel Road.
Hannah?
Yes, sir.
Mr. Hannah, do you solemnly swear or affirm the testimony given in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. So I just wanted to clear up a couple things here on the, Mr. Williams had Dinrec come in and put like a mound septic system. And when they put the mound septic in, they took the best part of this lot, which is right here in the middle. If you click to the other views that you show, it's a mound septic, and I mean, it literally takes up the whole chunk of the lot. There's nowhere else. So if you look on the property line right here, this line here, there's nowhere else that the trailer or the mobile home will actually fit, because the old one sat closer to the property line. They gave, I believe Dinrec gave him a variance to 25 feet instead of, I think it was 40 or something from the rear setback. He already got a variance to be able to put it closer to the tax ditch, and I think it's what's called blue line stream. This blue line stream setback from the other property, from the other side of this property. So if you take that 25-foot setback, we can click to the other one, I'll show you where I'm talking about, the aerial. There you go. So that blue line stream goes right through the middle of the septic. And if you take the 25 feet setback and that blue line stream, the only usable chunk to this property is right here. That's all you can do, and the access to driveway is over here. So there's virtually nowhere else anything can go. And we even, in trying to put a garage, I think we downed it to like 20 foot by 20 foot, about the smallest that you can get at one car. So there's really nowhere else for the garage to go. There's nowhere else for the mobile to fit either. It's just jammed tight. And there didn't really consider anything when they put the mound septic there, and it's huge. So it's like the best part of the property was taken up by the septic, so there's no other place to put it. And the driveway, this drawing, I mean, we've been back and forth a couple times looking at it, so the driveway actually sits on the other side here. There's that easement there, the right-of-way, whatever it's called, to the neighbor's driveway. There's still a good bit of grass there, so it's not going to be on anybody. It's not like he's taking middle of the road or 5 foot of the road. There's useless property there. They can't put a driveway there because it has to go to the tax ditch. So it's basically unusable property.
Anybody have any questions of Mr. Hannah? Thank you, Mr. Hannah.
Okay, thank you.
Is there anyone else that would like to speak in favor of this application?
If there's anyone joining us online that would like to speak in favor of this application, please raise your electronic hand and we'll let you into the meeting. I see no hands raised online at this time.
Thank you. Is there anyone that would like to speak in opposition of this application?
Again, online.
Williams, you can take your seat now. Thank you.
Thank you. Ma'am, if you would like to come forward, state your name and address and allow our attorney to swear you in.
Hello, Sharon Royston, 235 Thicket Road, Camden, Wyoming.
Did you say Royston?
Yes, Royston.
Miss Royston, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth and nothing but the whole truth and nothing but the truth? So.
Yes, that is true.
Okay, thank you. You can proceed.
Okay. I live in the property right behind it. So the part of the grass right here that's cut is mine. I can put a driveway in. That's my access. That's my access to my property. Right now, I use the shared driveway that goes alongside of it. I did have a question. It said 22 by 22, but the man said only a 20 by 20 will fit. So that's a little confusing to me.
Thinking about the garage or?
Yes, he said the garage would be a 20 by 20 would be the only one that would fit. On the paperwork, it says 22 by 22. And on that other picture, I'm sorry. The 5 feet, it's even kind of hanging over. It's a very small lot. You can't really tell too much by this photo. It looks a lot bigger. The lot is very small, and he's right. The mound system takes up a lot of it, which was just a bad deal. If a garage is placed there, it blocks a lot of view. And I don't believe the house that was there before was 70 feet either. It is a very small property. That river blue line that we have running, because I did have to go through a lot of DENREC issues when I moved in there back in 2021. I had a lot of issues, and I did the surveying and everything else. So I've been kind of through this, and he just got a bad deal with the land. But I believe if that garage gets put there, it's going to be extremely congested. And even when the man was coming out to survey it, he was on my property doing it. So I think I do have a little kind of bit of a say-so, because they're going to have to be on what they call dead space. But eventually, if I want to, I have a 30-year mortgage, I can make it a driveway and gravel it or pave it or do what I want, since it is mine.
Go ahead.
This is a question for staff. I'm not sure if I'm clear on what area she's talking about that she could improve in the future. Can it be pointed out on that?
So she's got a pipe stem lot also. So her property comes up here, and then it kind of expands back there.
Where the grass is cut was mine, is mine.
So she would be this property here.
And that was the trailer that was previously there. It doesn't look 70 feet. It was small. I think it was only a 2-bedroom, if that. I'm only saying that because I just can't visualize this at all. And like he said, a 20 by 20 would have to go there instead of the 22 by 22. And then also the mobile home size is a little off to me. And I have little children, you know, it's gonna block everything.
So I'm trying to understand. Can you point out on that thing? Tell me where your house is. You're right there, just on the other side of the.
On the other side is my actual house. Like right here, this is not my house. This was an old picture. Mm-hmm. I have a double wide with a 20 by, I want to say 23 pole building. I believe that's what it is.
Okay. So if he puts this garage where it's shown on the map, you still have quite a bit of land there in that pipe stem.
Yes, that's an access if I want to make it a driveway. Right now, I use a shared driveway with my neighbor. Mm-hmm. But if he sells his property, I might not be able to share my driveway and might want my own. Mm-hmm. Like I said, I just purchased this. I plan to be here.
Mm-hmm. Again, you still would have room to. I don't know where your property line is. If that driveway is on somebody else's property line.
That driveway is somebody else's property.
Okay, so your property line is the grass.
The grass, correct.
Okay, so there is room still to put a drive in there.
At the beginning of the property, it's a hole. So the property has a lot of issues in general.
Okay. Anybody else?
I kind of a follow-up question. If you consider where the garage is going to go, you made a comment about the view being blocked. Can you clarify how would your view be blocked if the garage was put there?
It's just the view to the road. The view to the road is completely blocked. The children's bus stops are up there. I am a single mother. I just have it on camera, so I know they get on and off, but it's a long driveway. So
you can see past the mobile home, you see through the mobile home, but if a garage was on the other side of it, you wouldn't be able to see?
I don't see how a mobile home will even fit in there, to be honest. I can't visualize it at all.
Okay. Okay.
It's just a very small piece of property. He got done a bad deal.
Okay. Anybody else? Questions?
Well, just to, Ms. Royston, this board is to consider whether neighboring properties are significantly impacted by the variance requested if it were to be approved. And you're telling us your property would be significantly impacted.
Yes.
And can you just, I know you've touched on it, but could you try and summarize how your property would be significantly impacted if these variances were granted?
I guess because I'm just having trouble with the sizing.
So when you say you're having trouble visualizing it, I don't know what the board can make of that statement. Can you be more particular or more specific as to how?
What I was saying with the sizes, he said 22 by 22, and then the trailer alongside of it.
So I think it's fair to assume that the garage is going to be 22 by 22. That's what was applied for. I understand that one gentleman indicated it had to be downsized to approximately 20 by 20, but I think it's a 20 by 22 structure alongside of a mobile home. That garage structure is going to be tucked behind the mobile home from your perspective, right?
It'll be in front of it, I think. The garage will be in front of his mobile home.
It will be in front of it, but you're behind the mobile home. So you won't see the garage, is that, unless you're coming down your new drive. Is that right?
Can you
When
put
I
up
walk
this
out the
picture so
front.
she can, guys, please? Okay, so the blue, of course, is the mobile home. The red is the garage. It's not sticking out any further than the mobile home. Does that help you get a more visual?
Yeah. I'm not understanding. I'm sorry. I've never done this.
So your home would be back here?
Yeah, my home is back there.
This would be their proposed home? And I believe what the board is stating is that you would be looking directly at the mobile home and wouldn't necessarily see this garage because the mobile home would be blocking the garage from your view of from your home.
So is what you're really trying to impart, and I'm asking, and I'm not trying to put words in your mouth
Yes,
because I can't. But I feel like what you really don't want is the mobile home to be there. But, he has a right to develop his property at the same as you do.
Yes.
Okay, so-
but future-wise, the driveway, if I tend to put it in,
You wouldn't put your driveway on his property.
it'll be right up, literally
It could be up against
it.
the line if that's, but you wouldn't, legally, you couldn't put your driveway on his property. And as you can see, there's 5 feet between there and your driveway. I don't know if I'm helping you or, I hate for someone to leave here and feel like we didn't listen, so, and we all.
I understand. I just don't know, I guess, how to express it, really, or explain it. I'm sorry.
Don't be sorry, you're doing the best. Anybody else? When she's done, you'll have an opportunity. We'll see if anybody else wants to speak in favor or against, and or against now, and you'll be able to come up, so.
Okay.
So, does anybody else have questions of Ms. Royston? Okay, so now you can sit down, and if he chooses, okay?
Please state your name and address and allow our attorney to swear you in.
Dale Royston, 235 Thicket Road.
Mr. Royston, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. All right, what she's trying to say, her house sits back where the motorhome, where he's planning on putting it, would be even with her house. She don't have a problem with that. The problem is the garage is going to be way over. That's what.
When you look at this picture and you see the blue mobile home and you see the garage, the garage does not stick out past the mobile home.
Yeah, but that ain't the size mobile home that was on that property to begin with.
But that's not a restriction, and he's not here for us to give him permission to do that. That's not a restriction, how big.
See, what happened when she bought the property, we had them come out 2 times and surveyed it. Nobody told her that plot of grass alongside of the other driveway was hers. We paid $1,000 to use that driveway to bring a trailer in. If we knew the property was hers, which nobody said when she had it surveyed, we would have had a driveway put in right then and there. The county, I guess, would have come out and put the pipe in the ground for the ditch. But since we come home one day and there was a bunch of stakes, I guess, when he had property surveyed. The next day, all the stakes were gone. Well, I didn't know what was going on. Then I come down and they put the septic tank in. And all the stakes were put back up. So I was talking to the man who put the septic tank in. I said, what are all the stakes for? He said, this is all Sharon Royston's property. I says, we never know it. Nobody's ever told us. We had it surveyed twice, paid to have it done twice, and nobody ever said one word about it. We paid $1,000 to have that double wide put on that spot. And she's got to keep paying maintenance on the road.
So, Mr. Royston, so your opportunity now is to address why it is that the proposed location of the manufactured home with the garage significantly impacts.
Well, it's going to sit further out because her house sits back.
So
you understand,
so
on the property. So when she comes out her house, she wouldn't be able to see the kids at the bus stop because.
But that would, so her objection is to the manufactured home equally.
Can he set it back further?
Send it back or to
Or
the,
set it, as you come in the road, set it back this way further?
so the testimony is that because of the presence of the
But
septic
still, I
mound,
don't think there's any room between where the septic is to even drive to the garage.
well, the testimony is that the home with the garage cannot be moved towards the left because of the presence of the septic mound, the mound system.
I don't see how he's going to drive into the driveway, do it with the way the septic tank sits. To put his,
That would be up to
to
him.
put his garage in.
That's up to him, where he wants to place. Maybe he's not planning on putting a car in it. That's up to him. That's his property, and that is where he legitimately will be able to put it if the board allows him the little, what he's asking for, the little variance he's asking for.
Well, this is residential property too. He runs a business. Is he running a business out of it?
He does not have to the best of my knowledge, we didn't ask him, but he doesn't have a business license because they would tell us that.
That would be a separate application.
Yeah, it's a
They would
separate
need to apply for
application.
home-based. That would be a separate application. He would need to apply for a home-based contractor or home-based business, but that would not come before the board.
And that's not before us tonight. What is before us tonight is that little red box that you see there. And it does not impact her vision because the mobile home is there. The other thing is, when you had a survey, were you not given a copy of the survey that showed where her property?
They only surveyed where the double wide sat was going to be put. That's all they did.
We didn't
Okay.
get the picture. This was the first time I seen the picture.
Okay.
Ms. Denny, if I may, the
I
variance.
mean, you paid all this money to have a survey. They should have knew that the property was there, right?
I can't speak for your surveyor. Sorry, I mean,
It was
I
the
certainly
state
would
come
have-
out and did it, or whatever he is.
If you're talking about for the septic, that would have been DENREC. So anyway, you were going to say something to me, Jamie, please.
Yes, ma'am. So the proposed variance that they are seeking is 5 feet from the side property line for both the home and the garage. Just to clear that up.
Jamie, can you show us one of those either photographs or diagrams? How
He stayed back 10 feet. There ain't no problem.
how Mr.
5 feet is 5 feet.
how Mr. Williams will access his property relative to that
How will he
common
get onto
driveway
his
now?
property?
Sir, that was a question for staff.
Right there.
Mr. Royston, that was a question for staff.
Oh, I'm sorry.
Jamie, can you show me how Mr. Williams will access his property relative to that common driveway and also the grassy part that belongs to the adjacent property owner?
Yes, sir. So Mr. Williams will access here. Ms. Royster accesses through this driveway over here that's not on her property. This would be her property here, and that's what she's stating she could potentially develop a driveway on. But if you see here, you can kind of notice in this picture where the grass is cut. That's Ms. Royster's property, and Mr. Williams is there to the left.
So Mr. Williams accesses his property not through the common road, but rather this old thicket road.
He would access right off Thicket into this driveway.
Thank you.
You're welcome.
Okay, does anyone else have any questions for Mr. Royston?
I do. So you're saying the 5 foot difference, because you said 10 foot wouldn't make a difference, or you're saying 5 foot would. If it was 10 foot,
If it was
that
10
5 foot difference would give you the line of sight where she could see the kids at the end of that
Yes.
long lane.
Yeah, with the cameras and all on her. Yeah, it goes all the way down. If the picture was over a little bit, you would see a bench where the kids sit on for the school bus. And the camera's on the tree up there. And when you put that 4 feet over, it's going to interfere with it.
So if we look at the picture up here, and it looks like there's a blue van sitting to the left of her property.
The van?
Yes, if you keep going, that house that I see between the trees,
Yeah,
is that her
that's
house?
her house. That's the garage, yes.
Okay.
And the house is in line with the garage.
Oh, so where the red cursor is the garage? Is the
Yes.
garage. So when she looks for the kids, she's looking out the garage.
Yeah, basically, yeah. A little bit over on one of them trees right up there.
Essentially, you're saying she's not standing at the end of the lane looking down or looking from window in her house. She's looking from a camera that has been placed in one of the trees.
Yes.
Is the camera able to be moved?
No, because that other tree in the front yard's rotten and it's coming down before it falls. The other tree's rotten.
Mm-hmm.
And that's got to come down.
And then is there not a tree behind it where it can be, or a pole that's something else to establish the camera? Because it's her property and she can put it where she wants. The camera I'm talking about.
Yeah. But there's nothing there, not unless I go and put the poles up and stuff like that.
Okay, does anybody else have anything? Thank you.
You're welcome.
Is there anyone else that would like to speak in opposition of this application?
If there's anyone online that would like to speak in opposition, please raise your electronic hand at this time. See no hands raised online.
Thank you. Seeing no one, the public hearing for application A-22-36 is now closed.
Okay, and so that calls the public hearing to a close, and...
We have one
I'm
more,
sorry.
Ms. Stenny.
Oh, sorry. Missed it.
It's fine. The next one is A22-37, Mr. Ruben Roca, the owner of is Berean Community Church Incorporated. Is someone here to represent this tonight? Just raise your hand for the moment. Thank you. We'll call you up in a minute. Oh, that's fine. Again, this is A22-37. They are seeking a variance from the requirement that only one double-faced sign, no more than 100 square feet in area, be permitted on the premises. Their intention is to place a second sign on the property. This property is located on the south side of the Milford-Harrington Highway, about 735 feet east of Bloomfield Drive. It's northeast of Houston. It's the 4th Levy Court District, and it is zoned AC. And this gives you some idea. At the bottom, you can see there is an existing sign, and that one was recently updated and replaced by permit not too long ago. The proposed sign area where they would like a second sign is up towards the top. You can see, and some of the photographs will show you where maybe a previous sign was placed to give you some idea where they want that second sign. So there is the posting, and you can see the sign they recently placed there off to the right. And this is looking down Milford-Harrington Highway, probably to the east. You can see the existing sign on the right. And this is another shot of the front of the church with the sign there. And this is again looking east, and you can see that a previous sign, just the frame remains now in the front. And this is looking towards the west, in the other direction. You can kind of see that sign frame again to the left, and further down to the left, you can see the current sign that they have. This is an aerial photograph. It almost looks like the old sign or something was still there, and the new sign still has soil or sand around it where it was placed. I believe these aerials, Eagle Eye, was done this winter, maybe March or February. And this is just a further up aerial to give you the character of the neighborhood, to give you some idea what is around the church. And a higher up elevation or aerial. Okay, Mr. Roca, if you'd like to come up, please. Are you indeed Mr. Ruben Roca?
Yeah.
I thought you'd be here tonight. Thank you. If you could give your name and address and allow our attorney to take it.
Okay, Ruben Roca, 6424 Pebblebrook in Milford, Delaware, 19963.
Mr. Roca, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do, sir. First of all, I want to thank you for being here and the great work you do, and thank you for taking in consideration our submission. So, yeah.
So if you'd like to say something, Mr. Roca,
Yeah, as I was going through a couple of comments when it comes to the character, if it's going to be affecting the area surrounded, I will say no. But at the same time, I want to base my comment not coming as a challenge to what was suggested by the board. All I want to say is when I came back from California to Delaware, I noticed there was a sign there before because I didn't assume that the sign was, I don't know, I didn't want to assume that everything was done in the proper way. So I called the county and I find out that, yeah, somehow the sign was put there. It was a previous congregation that was there. I do have pictures of that in case that you want me to provide that. But all that to say that even the former sign didn't affect or created any distraction to the traffic. There were no complaints done by the neighbors. Actually, because of this application that we submitted for a variance, at least 2 neighbors that I know that they will be not opposed or actually in favor of us having that sign granted. So that's the first comment, that I don't think it's gonna create any issue with the aesthetic of the area or that is gonna be a distraction. Actually, I will say, because I was reading and the recommendation was like, because we already have a double sign to make whatever we want to communicate, to put it there. But I will say, humbly submit to you that will be a distraction because it will be, too loaded and it will take more time for people to read. And specifically because of the population that we are targeting, which is the Hispanic population, as soon as they see the sign in English, many of them, honestly, they don't read English. So that's why with this new sign that we are asking to have the variance approved, what we're looking for is, first of all, it's going to be a permanent sign. It won't be something that is going to change. And pretty much it communicates the day of the service, which is Sunday, and the hour. So it's going to be Sunday, 2 p.m., Spanish service, in Spanish, of course. So that's all that we are communicating. And by having that small sign on the other side, opposite to the existing sign, actually, I think to us is less distraction, and it will capture the population that we are targeting, which is the Hispanic population. We are really intentional on being inclusive, and we are really making efforts to make that happen. So that's why we are even offering that service at 2 p.m. which our normal services are 10:30 a.m. So maybe what I'm trying to ask you for is if, because we understand the spirit of this board, which is serving the community to the best of your ability, and we honor that, and we want to be part of that. So if you, I don't think this variance we asking for is going to be in detriment for the same community that we are both serving. So I will ask you to have that sign granted to us to be able to serve this population in a more effective way. Yeah, I want to stop here, and if you have any questions, so please, I hope I can be clear in answering those.
Yes, I have a question.
Yeah.
If you travel up and down the Milford-Harrington Highway and just did your own personal survey of that highway,
Yeah.
how often would you run into similar businesses or churches having two signs?
Yeah, and I understand that in that sense it's gonna be different, and I totally get that. But it is because of the community that you're trying to serve, and that what makes it kind of like different. One of the churches, let's say Route 14 on kind of like all the way to Harrington, that's when you see, like if you're driving west, you're gonna see to the left inside one of the churches. But it is an American English-speaking church, so you don't have any need for the sign like that. Then driving from Harrington to Milford, you're gonna have one come almost making it to Milford on the left inside again, which again, it is a congregation that serves, American English speaking. So, and that's why you don't see the need for two signs. But what I'm proposing here is due to the community that we are serving, that kind of like creates the need to communicate in a way that is easier for them to see. And it was a previous sign there that actually nobody even noticed in the sense that to come as a complaint. So I'm appealing that to you that based on that reason, the community that we are serving and targeting, that this variance is granted.
I have a follow-up question. So
Sure.
if you consider the location where the old sign was, would I be correct in saying the old sign was there, the new one was not? So there was only one sign at all times?
Oh, yeah, when I say the old sign, I mean, I'm referring to the former Spanish congregation who was meeting in our building. They put a sign that I myself removed, and that is different to the sign that our church has, which is the double sign that I think we applied from 2021 to have it, build up. And so we are talking about two signs. The one that I'm asking for the variance is the small sign that is you're driving from Harrington to Milford is the second sign, kind of like east to Milford.
Yes, I'm following you. So that's my concern. Has there ever been two signs up at the same time?
Well, yeah. Once again, not because we submitted it, because the people just put it there. But when it was, to give you a little background to answering that question, I came back from California in July, actually to take care of this Spanish ministry. And when I saw that sign over there, I was like, well, I just want to make sure that this sign has the right permit. So what I did, I removed it and contact Kent County to ask, what was the status of that? And I find out that no permit was issued for that. So at that moment, I was already out with that sign. So now what I'm trying to do is honor the work you do and honor the law and come and apply. And that's what I did. And I understand now that a variance is needed. And I'm asking you if doesn't, conflict with anything. We just want to go with the law, what the law requires. And if it is possible that you grant that variance, it's going to be very, very helpful for the community that we are serving.
Okay, I'm following you, and I understand your request. You have a bilingual congregation and an English congregation.
That's right.
So you're trying to fit that need. Is there a way to modify the new sign to address that issue and not grant you a second sign?
And we, the elders of the church, actually talk about it. And based on what we know of the community, and I'm a Hispanic too, so I know the community. I've been serving the Spanish community in other capacities. So I know that what appeals to that community is a very short-worded sign that is in Spanish to communicate. What we're trying to communicate is that at 2 p.m. we have a service for them. And if we try to do that with a big sign, it's going to be very loaded and actually more distracted. That was one of my first point. It is going to be less distracted for the traffic having that little sign in Spanish, that having more words and expanding even the sign that we already have.
So would the second sign, the composition of the second sign, how different would it be than the current sign? Because I'm assuming the current sign is electrical lit, light at night. It's not, or it is?
Yeah, well, in that sense, it won't be the same type. And once again, I'll be more than glad to provide with 2 pictures that I have. Actually, it won't take me long. I have it on my phone, so you guys can see the old sign that former congregation had. The only thing they use for lighting, they have like 2 solar lights, so it will charge up during the day, and then they will be very dim. But even if we don't have lights at night, I'll be okay with that. As long as I have the sign and I'm able to communicate that on Sunday, 2 p.m., we have services in Spanish at 2 p.m., I'll be happy with that. Because it won't be that kind of sign. It's going to be a whole different sign.
So one last question. You're
Sure.
saying there will be exterior lighting that's projected on the sign for you to see. The sign's not lit.
Exactly right. It can be that 2 lights are put there that are not disturbing, or once again, I just, if possible, want to get the variance approved, and I'll be happy even if we don't have a light, and at night you don't see it, because at the end of the day, as long people see it in daylight, I'm fine with that.
I have a question. Oh, go
Sure.
ahead. No. So the sign as we see here doesn't, it's about the church, but it doesn't exist with the times of services. They're not on there.
Yeah, because
But there's room on that sign for you to add or change the sign and make and list the times of services. There's room on the existing sign,
yeah,
and it is a big sign. So in which case, if you would adjust, and for the cost of putting up a whole new sign, you certainly could readjust this sign to, and of course it's double-sided, and you could adjust it to have to change the wording and put the service times on there. That's my comment or question.
Yeah, and I appreciate it. That's one of the things we consider with a group of elders. You don't want to make it kind of like very convoluted and to advertise the Spanish service in that same sign, that will require for you to also advertise the English services. So then you start adding a lot of information that you don't want to communicate, all in one sign. And it's going to be a lot of words. It's not only that takes a lot of space, that to us becomes distracted to the traffic. Because you see the sign there, we are trying to communicate the basic. Berean Community Church is a church. And then what we do, Bible proclaiming, Christ is exalting. That's all we want to communicate. Then we communicate the services in different ways as people come and visit and all that. So, but if we add in Spanish, and in order to add the Spanish information, then we need to add the time of services. Once you do that for the Spanish congregation, you have to do that for the English one, and then you end up with a sign that it is very distractive. So we're trying to avoid that. And having that little sign on the other side that says, Servicio en Español, Spanish service, Sunday 2 p.m., Domingos 2 p.m. That's it. And it's not that kind of sign. It doesn't require lights and anything. We just want, because that's the thing. And I know in the spirit of serving the community, we strive for that, for safety of our community. Also, in the service that we provide as a Christian church, many things happen because of the gospel of Christ, changing, transforming people's life, and helping those people to be maybe not be on the road drunk or,
And see, that's not what we're here to consider.
I know, but what I'm saying is, because that goes along the fact that we both, you as this committee, and us as a church, strive for the same thing, which is the safety of our community. So in that spirit, that small sign, it is exactly what we need. Granted that this, variance is approved, of course.
Within the code of the county, and in keeping, that's developed, of course, in keeping with the comprehensive plan. The sign ordinances were extremely important as these to the comprehensive plan and the code were being developed. The biggest aspect is addresses what you're saying about not making it overly complicated and being overly distracting. And for whatever part I might have played at a certain time in some of this, I would say it was also to keep, to be a little more reserved about making our county look like south of the border as you're driving down to Florida. So that's the reason that these ordinances are made. And of course, our job here is to defend or protect our code and our ordinances. And so when we grant a variance, we have to find an exceptional practical difficulty to vary from what the rule is. And that is part of our job in protecting the rule. So there has to be something more than a desire to have a sign, or it's easier to read, and there's plenty of room on that sign, and you may have to change the verbiage, but there's plenty of room, as I see it, driving by it, to put put other communication on that sign. So just, that's my statement. Does anybody else have?
Can you point to the reason why you couldn't just use like a political yard sign that could say your message of like the services are in Spanish at 2? Like, why would the sign have to be like a permanent structure versus something that's temporary, like a banner or a yard sign?
I'm thinking,
There are provisions for temporary signs, but I don't know that that would meet your requirements. Those things were typically for yard sales and things like that. And as you just said, Ms. Hudson, maybe political signs, but yeah, I don't know that that will be a solution here. It's a good thought, though.
yeah, I just want to say that kind of like in the spirit of what Mrs. Dini was saying, that part of the integration that we are striving for is not to make Kent County look like south of the border. And to do that, you need to interact with that community that we're trying to serve and teach them American values. Like even myself, I'm not taking longer on this, but that's one of the reasons. I'm a proud Delawarean, a proud American. This is my adopted state. That's why I'm here. And I want to pass that into my community that I'm shepherd, of. So in that way, having that sign, believe it or not, will help me instill those values that you guys strive for.
I'm going to interrupt you here because we're kind of going on and on, but is not about the sign. And when I say looking like south of the border, I mean when you cross the border and there's like a literal sea of signs and lights and signs. It has nothing to do with the people or culture. We're all different. That's what America is about. We are used to be often hear the words a cultural melting pot where everybody gets along. So that's not what we're addressing here. And that's kind of apples and oranges. What we're addressing is we have a code, a county code, that protects us from people having 2 signs. If every business along the road had 2 signs, we'd have double the amount of signs. And so that's the purpose of the ordinance, is to protect our landscape. So I'm just saying that, we certainly hear a lot of these, and then we have a lot of reasons, just like yours, but that's the purpose of the ordinance. So just to say.
Thank you.
Anybody else have any thoughts or questions?
Mr. Roca, I just want to be clear. Staff has indicated that you have an additional 16 square feet based upon the permit that was issued. You could have a sign up to 64 square feet. Yours is, square feet. Yours is currently, 48 square feet? Yeah. My question is, how is it that you feel you could not communicate the message that you want to give to your potential congregation? How is it that you feel that 16 square feet is insufficient? Now, that's a lot of space. And then you'd only have 1 sign, and I think you indicated you wanted to say that you were having Spanish service and the time. Is that correct?
Yes.
You have 16 square feet on a sign that you can do it, that doesn't require you to appear before this board. And that would be in conformance with county code. So how is it that your message cannot be conveyed in that 16 square feet?
As I was saying, we are trying to avoid making that sign with a lot of kind of like verbiage and...
I understand, but that's not my question. My question is, how is it that 16 square feet, which is quite a bit of space, it doesn't allow you to communicate the message you want to communicate?
Because to communicate that message, that will require that sign will add all the other services that we are already having kind of like in place. So
would that necessarily be true? Because is the sign that you have there now, does it indicate what time your services are? Is it out on the other side, or Does that not appear?
No, it is the same as you see it there.
So you'd
and-
just be adding to it, and then the people who didn't want to attend the Spanish service, or I presume, would have to figure out what time they'd go if they didn't want to have the service in Spanish. Is that accurate? I mean, right now, they'd have to find out what time the service was because it's not posted on the signage, correct?
Yeah. Once again, it is intended to target a population that read less. It is captured by the Spanish signs and not the American signs. And by having this small, especially compared to that one, a very small sign on the other side of the driveway, to us, it wasn't something that will kind of like affect the visibility or it would make it dangerous. But once again, I just want to be clear on this. We do respect what you guys do, and if it's denied, of course we are fine with that, but we are appealing to you that it will be nice if we can have it granted.
If we make exceptions for anyone that don't present an exceptional practical difficulty, and you haven't convinced me that there is an exceptional practical difficulty, because you can have the signage you want. So if we make an exception for you, then the next person that appears before us says, well, you made an exception for them. And then that becomes precedent, and then every time somebody appears before the board, we're going to have to say, well, yeah, we did.
I would ask you just to ask questions of the witness.
Again, I'm sorry. The reality is, I'm asking you to tell me what the exceptional practical difficulty is, and I'm trying to explain why it's necessary for me to understand it.
His testimony is that the sign would be too busy for the audience, and it would require people who read in Spanish only to disregard all the English on the sign, so they tend not to read it. I think those are the professed reasons.
And that takes a lot of time away from the attention behind the wheel, and that is a safety concern. Also, if you let me just bring up the topic of the neighbors. No neighbors, as far as I know, have expressed any opposition to it. And I'm thinking that has to do with, they know what we're doing there, and how we are trying to serve them. By serving this community, we are serving the whole community. And I know, Mr. Nichols, I see you. But no, I just want to convince you with this, okay? This is my argument to you specifically, okay? Which is this. The reason why this is an exception is because this is something new that we are all dealing with, in a sense. So there are not bilingual churches on Route 14, as far as I know. So of course, it's gonna set a precedent, but we can do it in a way that is safe for all of us. And I don't foresee, to be honest with you, any other bilingual church.
There are bilingual churches throughout the state of Delaware. My question to you is, are there bilingual other churches in Delaware that advertise that they're bilingual? Yes?
But they are in a different geographical set and circumstances. Totally different. Here, I don't think, I'm trying to be honest with you, I don't think that small sign will affect the visibility, will affect the safety of the road, will affect the neighbors at all. And
it will affect our code. It will affect our code, and we're kind of going over the same thing. And I'm also going to interject that I know the Roman Catholic Church here in Kent County has bilingual masses in Marydale and St. Benedict's in Harrington, and I could go on and on and on. So there are other faiths that do have bilingual services, but they don't have signs. Just saying.
Well, going back to the code, I think it's part 4 of the code that says, first of all, the very beginning, let me read it to you. It says that the board is strongly consider all public testimony in making their decision. That's the one thing that kind of like to give you a peace of mind. As far as the people that I have talked to, there is no concern raised. Actually, a gentleman that lives right across the church, that he told me he will be okay with the sign. But then the number 4, and I know I'm taking a lot of time from you, so I appreciate your patience. Number 4 is that when I'm basing, and I'm kind of like keeping myself in the code, it falls again to the public, I'm sorry, I have missed my place here. I think it pertains to the public testimony too, and how that will affect it. But anyways, no, I truly appreciate your time, really. And I thank you, and I plead with you. I know I haven't convinced probably Mr. Nichols at all, but that's okay. That it will be nice if that variance is granted, and okay. So God bless you.
Thank you.
Yeah, thank you so much. Have a good night. Oh, do you have any other question for me? I don't know. Okay, thank you.
Thank you, Mr. Roca. I appreciate it. Is there anyone else in the room who would like to give testimony in favor of this? There's no one else in the room. Mark, is there anyone online who would give testimony?
If there's anyone joining us online that would like to give testimony in favor or in opposition to this application, please raise your electronic hand and we will let you into the meeting. I see no hands raised in line at this time.
Thank you, Mark. And after now, is there anyone in the room who would like to give testimony in opposition to this application? Seeing no one else in the room, no one online, Mark. So there's no one else online to give testimony in opposition to this application. Hearing no testimony in favor or in opposition to this application, I declare application A2237, public hearing is now closed.
Thank you. So at this point, we are calling the public hearing to a close. Does anybody need a break? Okay, and we're going to take a 5-minute break and we'll return. So our 5 minutes are up.
Sorry, I didn't know you were back.
Okay, so we're about to call the business meeting to order here. And will you call the roll to make sure we all made it back from break?
Sure. Ms. Hudson.
Here.
Mr. Jenkins.
Here.
Mr. Kusick.
Here.
Mr. Nichols. And Ms. Stenny.
Here.
Votes to, or the roll call shows we still have 5 members present, so we still have a quorum.
Wonderful, thank you. So first order of business is to approve the business meeting minutes from October 20th of '22. I'll need a motion.
I'll make a motion to approve the minutes of the Board of Adjustment meeting for October 20th, 2022.
And a second?
Second.
Motion and second, all in favor?
Aye.
Aye. Any nays? Hearing none. Minutes are approved. Notices of decision. And they are from from October 20th, and they would be decisions A 22, 27, 29, 30, 31, and 32. Need a motion.
I'll make a motion to approve the notices of decisions for the October 20th, 2022 meeting for application A22-27, 29, 30, 31, and 32.
Second.
Motion is second. All in favor?
Aye.
Any nays? Hearing none. The notices of decision from October 20th are hereby approved. Old business, we have none. New business, and it looks like there are no remaining applicants here, so we'll just go through them.
So we're having discussion on A22-33 about this fence.
Yes.
The applicant indicated that they might be willing to consider a different out footprint for their fence. Do we have to make a decision on that this evening?
Yes.
Yes, we have to make it, the application is before us tonight. We have to make a decision. And because we did offer to table and were rejected, he wanted to see what the outcome of tonight's meeting was going to be. So we do have to take some action. And as a matter of discussion, I'm just going to say, to me, when I see something like this, this is why we have the ability to grant variances, and the exceptional practical difficulty is the nature of his child's anomaly, which and it's really a safety issue that they have a higher fence. To do anything they can to prevent this child from getting out, getting lost, or possibly even worse. So that's just my comment.
Yes, I have one in regards to condition number 3, where it says it must not fundamentally alter the plan for the development and regulation of the community. My concern is that it would affect the regulation of the community. Maybe I'm off base, but
Well,
help me
I don't
out.
think it's worded, the words matter, so it's a question of not whether it affects the plan, but whether it fundamentally alters the plan.
So, Mr. Townsend, help me out with the regulation of the community, because that's a part of it.
Well,
We don't, this body does not address homeowners association regulations. That is a civil matter that is heard in a court, in the Justice Peace Court, actually. But I'm not going to suggest what the finding would be on that, but I do have my own opinion. But at any rate, that is not part of what we consider.
I'm just asking Mr. Townsend as our legal consultation to help me out, or why is that phrase on that condition if it doesn't apply to what we have to deal with?
Well, I think it does apply. This is an unusual application. This is not a typical application for us. I think it's the first application like this that we've had. And it is being pursued under the concept of a federal law which requires that qualifying individuals be awarded a reasonable accommodation from restrictions that would affect their housing if certain criteria are met. And quite frankly, the criteria are quite a bit lower than the burdens that are placed on normal applicants. It's not exactly clear to me whether we're to apply both standards or just the 3 standards that are included in your staff report. I think it would be safest for us to apply both the normal quick check criteria and these standards relating to reasonable accommodations. But I will tell you that in circumstances like this, there is an enforcement agency that asserts that the 3 standards appearing in your staff report are the applicable standards, and they are applied in a manner which is quite deferential to the applicant.
Yeah, I'm saying, like, so this is the yard that he is given at this current time, and reducing that yard is a big impact for these other boards outside of this agency. But I mean, just something to think about. And then the altar of the community. I mean, the 4-foot fence is there, but you also got to look at the disability aspect of it, the safety aspects. And I think as this board, I think we need to look at is there a safety, any visual impacts. And I think per the testimony given, as he stated, there's large trees beyond that fence and a monument sign that already impacts the visual at that corner. So it's something to think about.
He did say it was like the main entrance into the development there, so there's a lot of cars coming and going all the time. And having a family member that does have a disability like that, you can't watch them 24/7. Something happens, and to think if they were to get over the 4-foot fence and get hit, that would, the safety there.
Well, to follow that line of reasoning, he didn't convince me that with the 6-foot fence that wouldn't occur. That's just what I gathered. I'm familiar with that development only because I did some engineering in it, and that intersection is quite busy, to say the least. It's especially where he's sitting. I mean, that's the exit to the development.
So you don't think a 4-foot fence like that versus a 6-foot solid fence is not easier to climb?
No, I'm not saying it didn't. The 4-foot isn't easier because I can see how he
the
put
6-foot's
wire.
going to be a solid fence. It's not
Right.
like he's going to be able to have railings to step up on.
No, I just, you notice during the testimony, I asked him, would there be anything back there? Because he could be clever enough to just drag something in place and still get over that fence. That's what I was looking at. That's just me.
The other thing for me is that where he's asking for a high, solid fence, and oftentimes, I do not know the particulars about this young man, but often if you can't see it, the desire to approach it is less. And I feel that, interestingly enough, yes, he could get hit by a car, but he could cause an accident that could cause injury to someone who was trying to avoid him, which happens from time to time.
I could also add something that just occurred to me, and that is that I think it would be entirely appropriate if you were to move to grant the variance, to make the variance conditional upon the child in question residing at that location, so that if his residency ever changed, that it would be the owner's responsibility to bring the fence into compliance with the county code. And that would not be something that we would typically do under the quick check standards, because typically we're not placing that much focus on the individual characteristics of the residents. We're discouraged from doing that. In this case, we're actually encouraged, or it is a huge responsibility of ours to take into consideration the residents', in this case, disability.
Yeah, we've had a couple of these come up where over the years where we want to do it specifically for this particular instance. And interestingly enough, different council have had different opinions on that. And I like what you're saying, but if anybody desires to do that, we may need help with the wording. But again, based on what the planners have said and the anomaly that from this particular young man, well, I said what I thought. So
Help me understand. My problem is with the criteria number 2. It must be necessary using a but-for test to show that but for the accommodation and its ability to address the person's disability, the person will not be able to enjoy an equal opportunity to live in this community. During the discussion, it was clear that the applicant could accommodate their desires, do so within the ordinance, and not have to appear here. And in that scenario, the person's disability would be accommodated. So I guess I'm asking, why is it necessary? Why do we have to do this? Because he could get everything he wanted just by working within the existing ordinance.
Because this is what his current residence is right now. This is what he is used to, right? So if we adjust that any way, any form, it does have an impact on that. Person.
They've already adjusted it once. They've moved that fence on the western side of I think it's the western side of the property, inward. I don't know why. It seemed like maybe there was some issue with the HOA, but I don't know. But in any event, it was moved. So there's already been a movement. I just don't see why they can't get everything they want and not have to appear before the Board of Adjustments.
His testimony in response to that very question related to the loss of area, that their son would suffer a significantly reduced area within which.
But would there be a reduction in area if he stayed within the setback requirements overall? I mean, could he not get the same area in square feet just by changing where the fence was located?
I think ultimately he would lose area.
Would he?
He'd have to come into the blue line, correct?
Right. If he followed the blue line, I don't know if that's a reduction or not.
If you look at that bump out, he would lose area.
Well, he does, but if he followed, he's talking about the green line being the new fence, correct? Or the new 6-foot high fence.
The green line is what he has now.
Is that accurate, Jamie? The blue line is what he has now? That's not accurate.
The green line.
Oh, the green line is what he has now and what he will have, but it'll be a 6-foot fence.
Right.
But he could have the blue line, correct? And have the 6-foot high fence.
Correct. He could put a 6-foot fence on the blue line.
And if you take that total area in comparison to the green lines, that would be equal to or greater than, I think, just looking at, or
but that-
comparable close.
do you
But
mean
yeah,
that-
not the same spatial orientation.
But that would include the area in front of the house, which is not seeking.
Pardon?
The blue line extends in front of the house, and he's not seeking to fence in the front of the house. And my guess is the homeowners association would object even more strenuously to a 6-foot fence located in front of the house. That would be very unusual to have a 6-foot fence up against the house, or even a 4-foot fence behind the setback, but up against the house. I think that would be a very odd effort to increase the area.
The front of the house is the area that's along Magnolia Avenue? I'm asking staff.
Yes, so the house faces towards Magnolia.
Yes. Okay, because I think that's currently, maybe it's the place next door, that's the sales office there.
Yes,
Yeah,
I believe
that
the
appears
sales
so.
office is across the street. This was originally the model home.
Right, okay.
Sales house.
Okay, if there's no more discussion, then I guess we're looking for a motion and a
Well, I just had one more comment, and it's only about, and I know we don't regulate the HOAs, but if we grant that 6-foot fence at that location, good luck to the HOA, because the visibility is so high at that spot. It's everybody, well, not everybody, because the people on the south side of development can exit from another location. But I'd say 50 to 60% of the residents have to come out that.
But you have that large tree right in the background
and
of
the
it.
people there have to take the tree down. And they're, that's, yeah.
So remember, I think we heard testimony from Mr. Lafferty. He's not permitted to have a fence any higher than 4 feet. So we're only here, when I say permitted, I mean by the restrictions. We're only here with respect to the zoning code, which restricts the height to 6 feet if the fence is located behind the setback lines. Actually, I don't think I phrased that properly. It would allow for a fence of up to 7 feet so long as it's behind any front yard setback that's applicable. So if the applicant were to move the fence in the area that we pointed out, he's still going to have an issue with his HOA. If he wants a fence that's higher than 4 feet, and he clearly does and has demonstrated a need for a fence that's greater than 4 feet.
And I'm sure the HOA doesn't know the whole story.
Yeah, we didn't know it when we got this application in the mail. We didn't know the whole story. And the other thing is that the Americans with Disability Act, I think, were this like to, I don't know, but I would believe, and maybe Mr. Townsend would have more knowledge, but that relief from this for the Homeowners Association is in JP court, and if the same information is provided there, I can't imagine that this would not be allowed. That's how I feel, but I'm not the judge.
Well, generally speaking, restrictions are enforced in JP court. Oftentimes they're enforced in the Court of Chancery, but the implication here is of federal law. I think it's the Fair Housing Act or related acts, require that reasonable accommodations be given to individuals who meet certain criteria. I don't think that's a factual question for us here today. This child meets the criteria. There's no reason to think that he doesn't. In which case, there are state agencies that enforce federal law, and federal courts enforce federal law. So this is not going to end up in JP court. The HOA, if they don't get this worked out, is not going to end up in JP court. It's going to be a much more expensive scenario for them than that.
And for the homeowner, who I would assume probably has expenses of their own, with the child with such an anomaly, and just the cost of the fence alone. So on that note, I guess
Does planning staff want to add anything on any background on this application?
Well, there's extensive background that I don't know that helps the board decide whether a variance should be granted. I think Mr. Townsend is aware of, the background. I don't know that helps or it should be brought up for discussion here for the board as far as how this originated and came to the board. Suffice to say that the remedy was decided, since this is a variance for a fence height, that the board should decide it. And the criteria is a little different in the sense that the hardship is a disability. And we could argue whether that's a legitimate hardship or, the 4 quick check. But I think that's what's before the board. If there's a hardship to this family and not getting the fence they need to provide accommodation, reasonable accommodation to their son. And I think that's the question before the board. If you can see that they do have this hardship and that the fence will help alleviate that by being taller and blocking noise and visibility and preventing them from escaping.
Because of how long all of you have been here, I do, in the back of my head, remember a case where it was a backyard and a high fence, and it was because of a service dog. I mean, it was for a dog, not a child, but it happened to be a service dog. And because of the training and the person that they were assisting also needed like physical protection. And so the dog could become aggressive if he felt his owner was, it was in any kind of a danger. And so that was a long, long time ago. I don't believe that you were here possibly, but, so that, that's where you have practical difficulties. And in fact, as a matter of fact, I think that was one of the cases where somebody wanted to say, can we say only for this owner? Because that would, hoping that would soothe the rest of the people that in the neighborhood. And again, 30 letters. But, and of course, sitting home, we didn't know all this, but the one thing I thought to myself was, and it's just the nature of my background, I guess, but I immediately think, well, none of these they're all writing letters, but none of them have a child with this type of anomaly. So, so anyway, thank you, though, for telling us that.
Can we grant the variance limited to this child's special needs?
I think you can, whereas you generally can't do such things, that you can limit this accommodation, because the standard number 2 states that but for the accommodation that is sought, to address the person's disability, the person will be unable to enjoy an equal opportunity to live in that community. I mean, that is all about the person. So that tells me that the accommodation is not based on the characteristics of the property, but it's based on the characteristics of the individual. And there would be no need to have a variance from the code if that individual no longer was seeking to enjoy an equal opportunity to live in the community. So I think, and I've been able to do some quick research on it, and I'm comfortable saying that you can limit the variance to the child's residency.
By doing that, we might help the members of the community understand why the variance was granted, and at the same time, if the family no longer lived there, the child was no longer there, then that would give the opportunity for the community to ask that the fence be taken down in conformance with the restrictions under the HOA. I mean, that's Solomon splitting the baby, but
But no, I can't disagree with you. It seems to me as though if it's the property owner, if they move and sell the house, they should have that fence should go. And I think, unless my feelings are that may soothe these 30 people who all wrote letters. I don't know.
I tend to agree with you. I think that's a reasonable path forward, in my opinion.
Well, I think what you said is a very reasonable thing. If there's some way that we can put a condition that when he's no longer in residence, that fence must be lowered.
To conform to county code.
A lot of developments, I've noticed, in fact, one my daughter lives in, where these split rail fence at this height are what's allowed, and it's nice because you can see through the whole community. I mean, it lends itself to a beautiful urban setting. So I'm not disagreeing with the rule. It just doesn't fit for this particular case now. So I certainly think what you're saying is very reasonable.
I'll make a motion for A-22-23 that we approve, or 33, I'm sorry, 33, that we approve a variance to have a 6-foot, 13 feet setback on the condition as long as the child with
The disabled child.
okay.
Remains in residence.
The child with a disability remains in the residence. I make this motion based off the public testimony that we heard tonight and the staff recommendation.
I'll second that motion.
Okay, so we have a motion, a second. When you're ready, call the roll.
Thank you. Mr. Nichols.
In connection with A-22-33, I vote in favor of the motion. It's a necessary accommodation for the person's disability.
Thank you. Mr. Cusick.
I vote yes for the motion for application A-22-33, per staff recommendation, and as Mr. Nichols just said, it's a appropriate accommodation for the disabled child.
Thank you. Mr. Jenkins.
Support of application A-22-33 based on the testimony of the applicant in regards to the safety of the child.
Thank you, Mr. Jenkins. Ms. Hudson.
I vote yes per my motion.
And Ms. Stenny.
I'm going to vote yes. I do believe, without setting a precedence here, I do believe that in this particular case, with this child with such a severe anomaly, which endangers him as well as, if he could get out, could endanger the public in causing an accident. And therefore, I think that is practical difficulty enough for us to follow ADH guidelines and allow it.
Thank you, Ms. Stenny. Vote shows 5 yeas, 0 nays.
Having received unanimous positive votes, application A-22-33 is hereby approved.
So again, none of the applicants have remained, so if we take the next one in order, I guess we'll do A-22-36, Mr. Williams for the side setback variance.
if we're in the comment stage of this, I think there's a clear exceptional practical difficulty when you consider where the location of the mound septic is and the blue line stream and the 25-foot buffer for the tax ditch. It makes it tough.
I agree.
It seems like it satisfies all, all four quick check criteria: the nature of the zone, the character and uses in the immediate vicinity, the restriction doesn't affect other properties neighboring. I think we went over that a lot. And whether, and because it's an odd-shaped property, if there was a failure to remove the restrictions, it would create an unnecessary hardship. I think it satisfies all four, in my opinion.
I agree. So at this point, I guess we need a motion.
I'll make a motion to grant a variance from the 10-foot side setback for application A22-36 based on the fact that there seems to be a clear exceptional practical difficulty in terms of where to place this home.
Second.
We have a motion, a second. When you're ready, please call the roll.
Thank you. Mr. Kusick?
I vote yes in support of the motion for application A22-36 per staff recommendation. The hardship is there for the uniqueness of the lot, the different variables that come in effect with the septic and the tax ditch offsets. And I feel like it fits within that surrounding area.
Thank you, Mr. Kusick. Mr. Nichols?
In connection with A-22-36, I agree. I vote to grant the, what are we granting here? Pardon me? Senior moment.
Well, the motion.
The motion, thank you. Failure to grant the motion, pardon me, grant the variance, that's the word, would create an exceptional practical difficulty, and granting the variance does not affect neighboring property, and it's in line with staff recommendation.
Thank you, Mr. Nichols. Ms. Hudson?
For 22-36, I vote to approve based off the staff recommendation, and there's an exceptional practical difficulty on the owners with the blue line stream and trying to fit their home with the septic mound as well.
Thank you, Ms. Hudson. And Mr. Jenkins?
I vote in support of it per my motion.
Thank you. And Ms. Stenny?
I'm going to vote yes in favor of the motion. I think this is one of those properties that the lay of the land itself is an exceptional practical difficulty, and this property owner has managed to figure a way with this small adjustment given by this variance to provide himself a very small home and a garage. So not to set a precedence, but I think there is an exceptional practical difficulty.
Thank you, Ms. Stenny. So for application A22-36, we have 5 yeas and 0 nays.
Having received unanimous positive votes, application A22-36 is hereby approved.
Okay, so the last application of the evening is A22-37. Mr. Ruben Roca, represent the Berean Community Church for a second sign.
Okay, discussion or motion?
I just couldn't really see the need for the second sign. That's what I just couldn't see, the exceptional practical difficulty. I didn't know if you guys caught one or.
My comment was in regards to, I know he was here about a second sign for a church, but there's a number of businesses along that highway that could possibly decide they want a second sign for their business if they see this sign granted. So I know there was discussion about a church and similar churches doing bilingual signs. Even if you don't consider that, I think it's possible, something we should consider. There's other businesses all along that highway that could possibly consider wanting a second sign after they see this.
I agree. They could all want a bilingual sign. Put it up in Spanish and in English. Everybody. Make an exception here, then they're everywhere. But that notwithstanding, he's got 16 square feet per staff notation, on which he can enlarge the existing sign and put the service time and put it in Spanish. If that didn't exist, if he didn't have that ability, then it might present an exceptional practical difficulty. But I tried to ask, please help me understand how 16 square feet is insufficient. I really want to say yes, in the truth, just because, all right, is there something about Spanish that requires more than 16 square feet? He indicated there was, but he didn't provide testimony that convinced me that that was accurate. I believe he believes what he's saying.
Yeah, he was.
We don't want to set a precedence to have an extra sign, and this is Delaware, and it's Kent County, Delaware, and word of mouth spreads faster than a fire on a dry day in a wheat field. So I'm telling you that if you put that second sign up and it says some brand new shiny with something new on it, then there'll be one application right after another and a lot of questions.
Well, I think Mr. Roca just kept trying to emphasize that he didn't want to deal with those other 16 feet because if you put Spanish phrases on that sign, it's going to be convoluted and it would detract from that sign. So in his mind, the second sign is necessary because you're pulling the Spanish away from the existing sign, which in his mind would be too convoluted, was his words, if we put Spanish. And then he said, if I put Spanish, I'm obligated to also put English on there as well.
The whole sign's in English.
No, the hours and times, they're not on there now, but he said that if he puts it on there in Spanish, he'll be obligated to put it on there in English, even though it's not on there in English now.
Well, the service times aren't listed on the current sign.
That's what I'm saying.
Right.
But he said, I'm pretty sure he said, if he puts it on there in Spanish, he has to put it on there in English.
16 square feet. I do have a question of staff. The other poles that were on that site, that was prior signage that was not approved, and when he took over the church, he came to county and got an approved sign. Is that correct?
Yes, that's my understanding, Mr. Nichols. It was me he called initially, and, when they had the second sign, it was an illegal sign, but, he did the right thing in taking it down and then coming to ask to try to legally have that.
They did have two signs on that property?
I believe so. I mean, the frame is there, definitely. I don't know that we have an old street view sign that shows it. I mean, certainly the frame is there, and we can all imagine, and he suggested at one time there was a message board within that frame.
Or was that the sign that predated the existing sign?
No, the one that was the newer sign, the old one, there was one there as well. You can almost see when in the one eagle eye, you can almost see where the old one was just behind that square. Yes, Jamie, thank you. And then they built the new one right in front of that, and then that one went away. So apparently one time there might have been two signs, which was, of course, was illegal, but...
Do you know there was a case similar heard long before we were in this building, and there was a beautiful, old, big, practically a billboard-sized sign right as you turn off of 13 to go into Camden that was advertising Simpson Lumberyard, and it was gorgeous. It was had lattice. It was very craftsman, beautiful. And it got damaged in a storm, and the code said if it's damaged beyond a certain percentage of the sign, that it has to come down. It can be repaired, but it cannot be rebuilt, and it fell under that. And it was sad because it was it was historic. But the bottom line was, it had to go. So, sad but so, and you have to be careful with signs, because once you establish it, the other thing with signs is if you establish that they have permission to put up a sign, you can't, we have a freedom of speech rules that prevent us from telling them what they can and can't write on it, so.
Well,
I'll make a motion to deny application A22-37. I feel the second sign will alter the area. And I also believe the hardship is not there. As the staff recommended or stated, that the existing sign that's there now has additional 16 square feet that they could utilize to display the information they need.
second.
So you have a motion and second. When you're ready, if you'll call the roll.
Thank you. Mr. Jenkins?
I vote in support of denial of the motion for the variance based on the fact that I think it would be precedence setting if we
Deny my motion.
He said he
Yeah.
voted. He said he voted in favor of the motion
Yes,
to deny.
in favor to deny.
I'm good.
Thank you, Mr. Jenkins. Mr. Nichols?
In connection with application A22-37, I vote to deny the request for variance. I don't see that it presents an exceptional practical difficulty. They have ample space on a new sign to advertise the message. And it's not in character of the community, and it's per staff recommendations.
Thank you. Ms. Hudson?
For A-22-37, I vote in support for the motion to deny. I don't see where there's an exceptional practical difficulty, and I believe the second sign could set a precedent, and it is out of characteristic for the surrounding areas.
Thank you, Ms. Hudson. Mr. Kusick?
I vote yes to the motion to deny application A22-37 per my motion.
Thank you, Mr. Kusick. And Ms. Stenny?
I am going to vote yes to the motion to deny. I see no exceptional practical difficulty. And to quote my colleague, Mr. Nichols, there is plenty of space on the existing sign to put whatever is necessary to say. And so I vote no.
Thank you, Ms. Stenny. For application A22-37, on a motion to deny the variance, we have 5 yeas and 0 nays.
Having received unanimous votes to deny the motion, it's denied, the application is denied, and we're ready to go home.
I make a motion to adjourn.
I think he has to tell me the vote, and then I have to say it, that it's denied.
Correct. It's been denied.
Okay, so having received unanimous. Oh, I did say that. It failed. Okay, thank you.
Make a motion to adjourn.
Second.
All in favor?
Aye.
Good night, everyone.
One quick announcement, everyone. It's been a pleasure serving the board. I am finished with the county November 30th. I'm already retired, but after 3 years here, which has been a pleasure, and it's been great working with the board, I will no longer be here. Put faith in Jamie. Jamie obviously will do a great job, but